Good afternoon. How are you? How you feeling? This lovely Friday, May 16, 2025. Okay. How you feeling? Let me know in the comment. I want to share with you a great news. But before I do that, I'm gonna give a little practical advice on what just happened to one of our clients, and maybe you can share the practical tips when it comes to immigration, and maybe you can share this might help somebody. Okay. By the way, I am in Canada right now. I came for a wedding of my cousin. He's getting married tomorrow, and I'll be back Monday, and I might resume with my live sessions on Wednesday. So I'm in Canada, in Ottawa, the capital. I don't know how to say it, but the capital. Okay. Anyway, so let's start with this practical tip. Then I'm gonna talk about the great news that we have. It's a motion to terminate removal proceedings that was granted, but I will talk about the background story. The practical tip is this. A lot of people, really, because of this Trump administration, people are crossing the border to go to Canada to pursue their asylum claim in Canada, based on the Canada-US, I believe US-Canada Safe Third Country Agreement, which simply states that if a person has been denied asylum here in the US and they're crossing the border, Canada can take them if they meet one of those exceptions. There are 4 exceptions in that agreement. You have to meet one of that exception in order to seek asylum there. And you have to seek asylum in Canada within those 14 days. If you're coming to Canada, you have to pretty much talk to an immigration lawyer in Canada in order to be sure that you are going to be really prepared for that type of claim, right? But my perspective is for my client who was came to me after being denied asylum here in the US and crossed the border and didn't work out well for him. So I want to talk about that. So what happened was this client applied for asylum, I believe, in 2018, and you know how it takes forever. It wasn't granted by USCIS. The case was referred to court, and finally, in court too, asylum was denied. After asylum was denied, then he called me, because he wasn't my client to start with, right? He came after asylum was denied. Called me to get an advice. I told him what I think about appeal, how long it takes, and what are the possible options if appeal is denied and stuff like that. So I tried to advise him, but he said he's just going to go to Canada because he heard that people are crossing the border. If you've been denied asylum in the US, I have to go to Canada. I told him, you know what, I don't know a lot about the Canadian immigration system. I would strongly suggest that you talk to somebody who's there. But what I know is that if you meet one of those exceptions, there are 4 of them, the family, especially the family exception, then maybe you might get granted entry in Canada, right? So he crossed the border, got to the port of entry in Canada. They verified that, of course, his asylum in the US was denied, which was one of the requirements. And do you meet the exception of family, meaning you have a family member there who is willing to basically house you and stuff like that. I believe that was the case for him. But unfortunately for him, the family member, not sure if the family member didn't show up or the family member just didn't want to take that type of responsibility. Well, entry was denied. And when entry is denied, what's going to happen is that you come back to the US and you will be released back to into ICE custody, and ICE will detain you. And trust me, once they detain you, they will make sure that they transfer you. And nowadays they are transferring so fast, okay? They're transferring so fast that by the time the lawyer gets in touch with them, The person has already left CBP, and they're already in detention center, where they deem that jurisdiction is closer, right? So that's what happened to this person. He got denied entry in Canada and released back to the U.S. into ICE custody. ICE by CBP took him for 3 days. By the time he got in touch with me, tried to, into my appearance, the guy was already transferred to a detention center somewhere in New York. So now we are filing for motion for bond and custody redetermination. So basically, if we can get released on bond, which I'm not going to talk about the details, because it's when a person has been detained, it's a totally different game, different procedures. Maybe once they release him, I'm going to come with the story to explain. But what I wanted to really emphasize here is that if you don't understand what that Canada-US agreement clearly says, and if you don't get in touch with somebody who knows the immigration system in Canada, it's just going to get you in trouble. Mind you, this person was free here, right? He was just supposed to apply for file for an appeal and then just wait or whatever, but now in detention. But thank God I already filed for appeal, but now we're fighting so that he can be released on bond. So, but he's still under ICE custody, right? So that's my point. If you go into Canada because asylum was denied in the US, you have to know what exactly that US Canada safe third country agreement says, really, if you meet those requirements and if one of those exceptions applies to you, okay? Yeah, that's just, I wanted to really emphasize. Since I'm here in Canada, I thought might as well just talk about it, okay? That was my number one. Number two, motion to terminate removal proceedings was granted. This is really a very unusual type of story. This person entered the United States, I believe, in 2015. I wasn't even a lawyer back then. I was in law school. I guess that was my last year in law school. I became a lawyer in 2019 because I had to work first, right? The person got to the U.S., applied for asylum. It took forever. Finally, he came to me, I believe, in 2022, 2023, to file for an expedite request for a file. It was granted. We went to the interview. The interview went so well. Unfortunately, the interview did not result in a good, basically, asylum was denied by USCIS. But what's so unusual about the case, asylum was denied by USCIS, the case was referred to court based on the fact that although the person had credibility, he was able to establish past persecution. Unfortunately, what they said in the referral letter is that you can't prove that you'll be persecuted in the future because his asylum was political, right? They say that the political asylum in question, basically the political system in question has changed, so substantial change in current government. There's no future fear of persecution. That's the only reason his case was referred to court. But listen, what happened was they referred the case to court. They issued a notice to appear. I was so convinced about this case that the guy was going to actually get asylum from USCIS. But anyway, it was referred to court. They issued a notice to appear. But after issuing a notice to appear, 20 days later, they issue him a work permit with the code A5, stating that asylum has been granted, which was like a shock to us because the person is already in removal. How come they issue him a work permit saying that asylum was granted, but unfortunately they did not issue I-94 or an approval notice? So we went to court, we entered our pleadings in writing, and we denied all those allegations of charges of removability because the person was in fact granted asylum by the simple fact that he had been granted by USCIS, not himself, by USCIS, a work permit under A5. asylee type of code. So I told the judge. Then we waited for DHS to respond. DHS never came back with evidence, and then the case was just pending. And then I reached out to the court. Then the court scheduled us for a conference hearing, like basically a contested hearing, so we can contest evidence. And DHS did not show up to that hearing. So then we filed a motion to terminate, and the judge based on asylum grant. So that's how we went with that. And then the judge granted asylum. Sorry, the judge granted that motion. So the motion that we filed to terminate, we filed it based on grant of asylum, because we had a work permit that says A5, but we don't have I-94. So now what is next? The next step is that since that the removal has been terminated, so now we can go back to USCIS to ask them to issue the I-94 and the approval notice, because they never contested those allegations, those charges. They didn't even show up. So they conceded. So we're waiting for USCIS to respond. If they don't respond, then we'll go to federal court to get federal judge to make USCIS to comply with the immigration judge order. So that's very unusual. It really if it was a mistake, they could have come to the hearing and say it's a mistake, but no clear and convincing evidence to remove a person. You have to have clear and convincing evidence. You don't have it. And in that case, the person was granted asylum. It's just that you guys, basically you came with that work permit after. So basically, in other words, you changed your decision, and which I think they might have changed it, because the way the asylum interview went and the type of evidence we had was really good. Let's say USCIS had to DHS, let's just say in case the DHS came to court and maybe stated that it was a mistake that they granted this work permit, we could have won this asylum in court, because the case was really good. I was even surprised in the fact that the case was referred to court. So now we're just waiting for USCIS to issue I-94. We are proclaiming victory, because at least in court we won, and see how it's gonna play out. I'm gonna continue to update you. This was really interesting. By the way, if you need a consultation, I'll be back Monday, so you can schedule your consultation on Tuesday, okay? Have a great evening. And now I'm waiting for the people to come so we can go and enjoy our weekends and the wedding and all that. Until next time. If I have I get too happy, I might just make some small videos for the wedding and show you on my IG story. Okay? Until next time, bye-bye.